Recording.
All right, thank you. So I can see by your backdrop, this is Ohio, but just want to make sure this is Unit 5, correct?
Correct. Yes.
All right, great. We'll introduce ourselves, have you introduce yourselves, and then we'll go ahead and get started. I am Lieutenant Colonel Kurt Mavis. I'm an attorney for the United States Air Force and have been doing that for about 12 years now. And I'm an alum of the program from your neighbor, the great state of Indiana.
Hello, my name is Richard Leiter. I'm a professor and director of the Law Library at the University of Nebraska College of Law, Lincoln, Nebraska. I've been here for 20 years.
Hello, everybody. My name is Candida Steele, and I'm a judge on, are you not hearing me?
No, we are.
Okay. I'm retired as a judge on the U.S. Civilian Board of Contract Appeals. I handled federal government contract disputes around the country, and I'm from Maryland, and I have quite a lot of family from Ohio, so it's good to see you all here. And I've been with the program for about 20 years.
All right, if you can introduce yourselves, please.
My name is Rowan Genevieve.
My name is Ethan Ernst.
Hello, my name is Saki Bausar.
My name is Ethan Bodnarek, and our teacher is Mark Dickman.
All right, well, welcome to you all. We are going to discuss question number one. I'll read question number one and then listen to y'all's answer. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of the decision, and why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have the courts balanced religious beliefs with other rights? Over to you.
Mr. Chairman, while protecting the free exercise of religion is very important, the result of the 1972 Yoder versus Wisconsin's decision has enabled parents to negatively impact a child's future by denying them access to a quality education. Even though the courts must attempt to balance the interest of the state with one's individual rights, the Supreme Court asserted in the 1982 Findlay versus Doe decision and the 4th District Court of Appeals in the 1983 Doe versus District Attorney decision that a child's interest should not be extinguished by the status of the parent and that a child's future well-being must also be considered. Finally, while the Yoder decision opened the doors for homeschooling and allowed parents to compromise the quality of their children's education, the court has maintained its position from the 1925 Pierce versus the Society of Sisters decision that it is reasonable for states to regulate all schools, to inspect, supervise, and examine them, their teachers, and their pupils.
Mr. Chairman, even though the right to an education is not specifically mentioned in the U.S. Constitution, it has been addressed as a right for certain groups under the Equal Protection Clause of the 14th Amendment. As seen in the 1973 Supreme Court case, San Antonio Independent School District versus Rodriguez, education is not a fundamental right found in the federal Constitution of the United States. However, the right to equal access to education has been guaranteed under the 14th Amendment's Equal Protection Clause, started by the landmark case Brown versus the Board of Education in 1954. Findlay versus Doe in 1982 required access to and funding for the education of undocumented children, and Florence County School District 4 versus Carter in 1993 required free, appropriate public education for children with learning disabilities. Furthermore, even though the Constitution does not include the right to an education, Article 26 of the Universal Declaration of Human Rights, which the United States is a part of, does enumerate education as a human right.
Mr. Chairman, since the Northwest Ordinance of 1787 first stated that education shall forever be encouraged, states have had the primary responsibility for the maintenance and operation of public schools under their state constitutions. While the Northwest Ordinance established the foundation for a right to an education, each state has addressed that obligation differently under their state constitutions. In doing so, state legislatures are tasked to provide a system of education whereby children will receive an education in a manner consistent with their constitution. While every state's constitution provides for an education, the role of interpreting these provisions has fallen on the state courts as seen in the 1992 Budd versus California decision, in which the California Supreme Court ruled that education was a fundamental right. However, determining what these constitutional provisions actually mean can prove difficult as seen in three separate decisions in DeRolf versus Ohio from 1991 through 2003.
Mr. Chairman, in attempting to balance First Amendment religious freedoms with other rights, the court has needed to weigh the rights of individuals against the secular interests of the state. One such conflict was seen in the case of Adele Sherbert, who was denied unemployment benefits due to her refusal to work on the Sabbath. The court ruled that this was in violation of her free exercise. This reasoning has since been interpreted to only apply to laws that are not generally applicable or cases where there is reasonable government interest, as seen in the 1990 case Employment Division versus Smith. The Establishment Clause has been balanced using the coercion test, which was meant to determine whether the government was advancing or suppressing religion, as witnessed in the 1992 Lee versus Weissman decision, which ruled that religious leaders offering prayers at public school was unconstitutional. You're now ready for your follow-ups.
Great.
Great. Thank you very much. I appreciate that. So you mentioned a couple different times in your opening statement about equal access. Did Wisconsin v. Yoder actually limit the access to the public education?
Mr. Chairman, I don't think Wisconsin versus Yoder limited the access to education because students still had the opportunity to attend school after 8th grade and receive that high school education. Their parents of the parents of the students just decided that they didn't want their children to receive that, so they pulled them from the programs.
But what the court did was allow them to do that.
Correct. It didn't limit the equal access because they still had equal access to the education. The court just allowed a family for religious reasons to decide the right amount of education for their child.
If I can just ask the next, then I was interested to hear also in your speech you talked about coercion tests. Can you elaborate on that a little bit?
Madam Chairman, yes, I can. The coercion test is the balancing test that the Supreme Court and district courts, as well as state courts, have used to decide whether the government was advancing or suppressing religion in cases where the Establishment Clause has become under review. This can be seen in cases such as school funding for private schools using that money to benefit religion, or cases where people are actively suppressing religion. So what the coercion test does is it takes the Establishment Clause and it looks at it through a lens of suppression or advancement. And that's how the Supreme Court decides on those types of issues.
Okay.
The question addresses Wisconsin v. Yoder. I'm curious if you've considered Justice Douglas's dissent in making its decision. How important should the student's right to an education be weighed against the parent's religious belief? Oop, I said that incorrectly. The child's religious belief be taken into account when deciding the parent's decision to continue the education. I hope that was clear.
Can you restate that, please?
Yeah, I'm sorry. How important should the child's religious belief be when the court is considering whether the religious belief or objection to education is important?
Mr. Chairman, I personally think that the child's religious belief should be very important, but I also think that a child should at least receive an education until they're 18 or their 12th grade. And after that, when they're an adult, they can decide whether to carry forward their religious beliefs or like if they want to not follow them. And
I would like to add on to what my colleague has said by saying that although the decision of the parent is their opinion should be respected by the court, I believe that the court needs to look at the future success of the student and getting education, because we've seen a direct relationship between the more education you have, the more likely you are to land a good job and be able to maintain a good household. So I think we can see that although the parents do have a responsibility to instill, or in this case, instill their religion upon their child, less of a responsibility, more of a choice, I believe that the state should look at the child's opportunity as well.
Now again, to go back to your opening statement, you mentioned Smith and discuss the precedent that has. Do you think that the Yoder court used the appropriate test, or compare and contrast that with the Smith decision?
Mr. Chairman, I believe the Smith decision and the Yoder decision, in a way, are on different grounds. In the Yoder decision, it has more of a moral standpoint of whether a child's right to an education, which directly inhibits or advances that child's future, is called into question, whereas Smith deals with an illegal substance being used for religious purposes. So,
but at the heart, aren't they both free exercise clause problems? And so, do we really want the court going into and evaluating the religious beliefs themselves?
Yes, you are correct in saying that it is a free exercise issue. I also believe, though, that there is a difference between somebody's. I think that there needs to be a different way to weigh the issues, because in the Smith decision, it talks about laws that are generally applicable or cases where there is reasonable government interest. I don't see as much of a legal reasonable government interest in the Yoder decision as I do in the Smith, where it discusses criminal legal actions.
So, do you think, for example, that governments, that's an interesting balancing test that you're looking at. Do you think that that's an appropriate way to approach questions of whether governments should assist parochial or private schools? Or not?
I believe that that private schools should be able to receive government funding as long as that government funding does not provide their religious services. So as long as they aren't advancing their religion, then I believe that they should receive funding for things like land grants and like building a gym, because that would be because that's not used for religious purposes necessarily.
Madam Chairman, if I may add on to what my colleague has said, the state and the government should be able to provide this funding as long as it doesn't provide the parochial school or the religious school a extra advantage over what other education systems may have. So like he said, they could provide funding for a gym or something like that, because other public education schools that are funded by the states, they receive those, but it can't provide money for, say, teaching education.
All right, well done. Thank you. All right, great. We'll provide some quick feedback. Thank you all. Richard, I'll turn to you if you want to start us off with some feedback.
Thank you. That was a very provocative introduction that you had. I really appreciated the the arguments that you had. You pulled in some arguments that were somewhat novel, and I really was intrigued by your pulling in the Universal Declaration of Rights, and I'm sorry that we didn't get a chance to explore that that topic. But I thought you all did a very good job. Thank you.
You want me to go, Kurt?
Please, sure.
I thought that was a really lovely job. Thank you. I appreciated your focusing on education as a fundamental right or not, and its development in that direction. That was very interesting and helpful. Bringing up the Northwest Ordinance was intelligent, and the coercion test. You clearly have done a lot of research and exploration in this question, and you've what's the word I'm trying to think of? You've synthesized it well into response to the questions. And so I hope that you've enjoyed this experience, that you've been bitten by our incredible government. And I hope that if you're not interested in going into political representation some way or another, up or down, you at least will, I know you will be wonderful citizens and educate the people around you and pay attention to what's going on. And so we're going to be sleeping a whole lot more easily, those of us who are a few generations ahead of you, knowing that you're going to carry forward for us with real knowledge and understanding. So I hope you'll continue to use this experience and go vote every time you can and represent us down the road. Thank you. You did a lovely job.
Yeah, I agree. The breadth of your opening statement was really impressive, and what you were able to synthesize. Good word there. One thing I'll encourage you to do is I think you all are on the right track during your responsive answers. I think they were responsive. What I'll encourage you to do is use some of that case law that you have bouncing around in your brain and use it to your advantage. And so when we talk about specific cases, try and call the quotes from the case, try and use the specific tests that the cases use, and then that just bolsters what's already a really good argument. So it's just a way to springboard to that next level, because I think you all had a really good demeanor. It felt like a conversation. You were responsive to our questions. So I really enjoyed it. Thank you all very much.
Thank you.
And now you can take a deep breath for the day.